This is a case related to a failed agreement to sell an immovable property, and finally, that was not treated as financial debt under Section 5, subsection 8, and Clause F. This judgment was delivered by NCLAT in the case of Sugan Chaudhary versus Arun Enterprises. This judgment was, in fact, given on 2nd May 2025, and we are bringing it to you because it is very important judgment, because there are many cases where some property has been sold to another person before CIRP. Part of the money has been taken as advance by the corporate debtor and the insolvency starts. Now, what that prospective buyer will do, whether he is a financial creditor or not, whether he has a security interest or not, that is something which is a discussion, and that is something which is very, very important and key issue nowadays, because there are many such issues which are coming. When it comes to the home buyers, then the same section 5, 8, and clause F is used to make them a financial creditor, maybe unsecured, but that same section is not being used for any other isolated property buyer. Now, in this particular case, the property ownership, the corporate debtor, which is Mansfield Cables Company Limited, owned an industrial property at Greater Noida, and that was in fact sold in 2016 by way of a registered agreement to sell, and that was sold to Mr. JPS Chadda and the director of the company, and also it was sold to Arun Dheer, the partner of Arun Enterprises, and the sale of the said property was for a consideration of 3.65 crores. Partial payment was made. First, 51 lakhs was made, and then another payment was made, 50 lakhs, and then in total 1.24 was made. Now, this agreement, then it was cancelled. In 2017, that agreement was cancelled, and it was due to failure of the corporate debtor to execute the sale deed. It provided that the corporate debtor would return the advance amount with interest at the rate of 2% per month. Post-dated checks were also issued by Mr. JPS Chadda, out of which only 2 checks were cleared and the rest of the checks were dishonored. In a settlement agreement was also entered, and that was executed, and in that settlement agreement, 2% interest clause was written. Only 2 checks were cleared, and then again it was default. And initially, in 2018, CIRP was initiated against this company by another operational creditor, and that matter was settled. Then this Arun Enterprises, in fact, started the first, again, Section 7 application, and that was also dismissed by the NCLT, and a fresh application was filed in September 2019, and again under Section 17, and the NCLT, in fact, admitted the application. NCLT admitted the application, CIRP of the company started again because the dues were 1.31 crore. Number 2, the amount was shown as unsecured loan in the financial statements, balance sheets of the corporate debtor, and there was no pre-existing dispute, and there was an interest clause of 2% in the settlement agreement. Based on all this, NCLT allowed Section 7 application, and the appeal was filed before NCLAT, and an interim stay was given by NCLAT in July 2022, and the final judgment was reached on 2nd of May 2025. So in July 2002, the appellant offered to deposit 1.5 crore, and the tribunal passed an interim stay on the CIRP, and the amount was in fact subsequently deposited. It was deposited from the personal account of JPS Chadda in the court. It was deposited. So now, that the total amount which was part of this application under Section 7 was 1.31. It was settled for 1.5. It was paid. And then this process, in fact, process remained stay. Now, the core issue was whether this failed agreement to sell the immovable property, wherein the seller agrees to refund the advance with interest, can be treated as a financial debt as per Section 5, subsection 8, clause F. Now, in this particular case, the central question formed the basis of the NCLT's examination, and final judgment, the tribunal had to determine whether the transaction between Mansfield Cable Company Limited and Arun Enterprises constituted a financial debt that would justify the initiation of CIRP. This is what is the now let us understand NCLT's finding, NCLAT's finding. NCLAT said that it is a commercial transaction. It was not that. When this was the transaction was entered into, it was a transaction for sale of immovable property. The tribunal's observation was, when we look into the real nature of the transaction, it is amply clear that the transaction was for sale of immovable property. The amount transferred to the corporate debtor was towards part payment of the consideration, and the interest of 2% was only in the settlement. The purpose of disbursement is important, and the purpose of disbursement in this case was not for time value of money. Therefore, the interest clause, whatever is there in the agreement, is not something which is determinable. In this case, Section 7 cannot be simply determined based on that interest clause which is there in the settlement agreement. And the substance over form. The tribunal emphasized that the substance of the transaction must be examined rather than merely looking at the form or specific clauses of the agreement. The original intent of the transaction is important, and this one, that this showing in the balance sheet as unsecured loan cannot be considered as a conclusive evidence. Then the substance of the transaction, it is not the debt, and also the accounting treatment is not decisive. Accounting treatment in the balance sheet is not decisive. So the NCLAT have seen the substance of the transaction, the original intent at the time of transaction. So ignored this 2% interest clause. There was the disbursement, but then disbursement was not for the purpose of debt. The disbursement was for the purchase of property. So therefore, NCLT finally said that based on various Supreme Court decisions, the time value of money, in any case, finally, the nature of transaction was important, and it was considered as error of NCLT. Section 7 application is not maintainable. It was a commercial transaction, and the order was finally passed that Section 7, Section 7 application, the order initiating CIRP was set aside. This was dated May 2022, and it was set aside on 2nd May 25. So all this 2.5 years or close to 3 years, the company continued under stay. The CIRP was closed, and 1.5 crore, which was deposited, that was even directed to be paid back. Let us see what happens. But this is a case where anyone who actually is buying a property and then that company goes into insolvency is definitely in trouble. His money is there and the company is into insolvency. He is not sure whether he's a financial creditor or he's an operational creditor, and how he has the right of specific performance on that property or not. Something which is not really good for the overall business environment of the country. Thank you very much.